Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. On January 30th, 2025, an item that we have been waiting for hit the docket in Idaho versus Koberger. It was filed January 28th, 2025, and it has to do with a request by the parties via stipulation to move matters set forth in the pretrial and trial order. This is the stipulated motion to extend deadline to file motions in limine, which are extremely important pretrial motions, going to excluding possible information, even evidence from the case. And it says here that comes now Brian C. Koberger by and through his attorneys of record, and with a no objection from the Latah County Prosecuting Attorney's Office, hereby moves the court for an order to extend the deadline for both parties' motions in limine. The court's October 9th, 2024 scheduling order, this is really the pretrial and trial order, but there is scheduling set forth therein for various matters, including motions in limine, which appear at page 2 under the motion section. Scheduling order established motion deadlines for motions in limine, and now going on to page 2, it continues. This motion, this means the stipulation, is made on the grounds that the discovery in this case is extensive. The defense, although diligently working, has not completed review of all discovery. The state received defense's discovery on January 9th. Additionally, the parties have recently exchanged expert disclosure, and additional time is needed to identify and prepare issues for filing motions in limine. So this seems to go to what we were positing out there, that these motions in limine would go to certain discovery and to expert witnesses, because these issues are listed here as good cause by both sides to extend the motion in limine deadline. Then it goes on. Additionally, the parties have recently exchanged expert disclosures, and additional time is needed to identify and prepare issues for filing motions in limine. The parties have discussed additional time for motions in limine, and the parties propose the following schedule. So this is what they want things changed to. Motions in limine, both sides. Right now, that deadline is the 10th of February. They want it changed to February 24th. The responses in opposition from both sides, currently due March 3rd. They want it changed to March 17th. The replies, currently scheduled to occur on March 17th. They want the deadlines moved to March 24th. They go on and say, the parties note that the deadlines above propose a 2-week extension for the initial motions and responses and a 1-week extension for replies to allow more time for the court and staff to review. Now, the above schedule, they say, allows the party to maintain the April 3rd hearing date, which was something that I raised. Would this also require a modification of the hearing date currently scheduled for the 3rd of April, and if necessary, continuing on to the 4th. The parties claim here, however, the parties will be prepared for hearing at such time that the court deems appropriate. Signed, Ashley Jennings and Ann Taylor. Now, maybe the parties believe that they're going to be prepared, but that doesn't mean that Judge Hippler and his staff, we learned he has a staff attorney, will have sufficient time to go through these matters. I seem to take a little bit of a dispute, this is my opinion, that the court doesn't look at everything until all the matters are filed. The court and staff attorney in such a high-profile case may be looking at these motions when they're filed and looking at what case law is cited in supporting the motions and replies and responses, not just the replies. So we're going to have to wait and see if the court agrees with this, if it'll require a change in the hearing dates, and what else it might require being changed, if anything, in the pretrial and trial order. This is Kathy. Thank you very much for joining us here today.